Just giving her a hard time because I was like 8 o'clock. Yeah, 8 o'clock. What?
Are we on? Thank you. Mr. President, we're honored to have the Senate here with us today at our conference committee. Vice Chair, Ranking Member, I think we all know each other, so we've been here before. Yes. That's exactly what it feels like. 4 senators to 2, so. You do? I've got a great vice chair here. You know, and what's brought us here? I mean, because of the federal mandates, the Biden administration, they put employers in a difficult position. Thank goodness we've got an attorney general that is fighting this. And I'm very hopeful when he goes to the 6th Circuit, we will prevail. And a lot of this that we're doing tonight may not, it may be a moot issue. But what I would propose, Mr. Chairman, is that have the reviser give us an overview, quick overview of the House version and a quick overview of the Senate version, if that would be all right. And I don't know, do we have clean copies, Jason? Okay. Well, we are kind of, you know, on a special session, that's the way things work sometimes. Well, I think that we should get to that. But I understand both the House and the Senate, we've done good work today. We put in our hours for the $88.66. Yeah, if you would stop giving each senator their own microphone. 125 of us share one.
Ready?
Go ahead.
All right. Thank you, Mr. Chairman. Jason Thompson with the Office of Reviser of Statutes. Both of the PDFs should be out there soon. I know the House Bill 2001 as amended by the House on final action is out there. The as amended by Senate on final action is not up yet. I know they're working to get that up as soon as possible. So it'll probably be easiest to start with, if you don't want me to highlight similarities, I will just highlight differences. You all know that.
That would be good.
Okay.
That's agreeable.
Okay. So you have the same basic provisions as far as the exemption itself in like subsection A and subsection B. And then subsection C is where you get your first major differences. The House version just provides that an employee aggrieved by a violation of the section can file a complaint with the Secretary of Labor. And they can allege any number of violations potentially under the statute, including punitive action or improper denial or failing to offer exemptions, for example. The Secretary then reviews that complaint and conducts an investigation. They are required to complete that and issue a final order within 25 days was the amendment on the House floor. It was 100 days as introduced this morning. So the Secretary would have 25 days to complete their investigation and file an order. And then the order would specify that whichever party was unhappy with the decision would have a right to appeal under the Kansas Judicial Review Act. And at the same time, the Secretary would send an order that found a violation to the Attorney General, and the Attorney General would be charged with enforcing that order by filing an action in court to impose those civil penalties in a Kansas district court specifically. I think the numbers are the same in both bills, like the per violation number, so I won't go into that. And how you determine the civil penalty, I think that's the same in both versions, but I just thought I'd point that out. And I think under both, the penalties go to the State General Fund as they're drafted. So jumping then to the difference on the Senate side on subsection C, the employer who fails to comply with this section and terminates an employee based on a vaccine requirement would violate the section. So it's limited in the Senate version to only in the scenario where someone is, where the violation occurs and a termination occurs. So it's not as broad as the House version. The secondary difference would be that the Secretary of Labor does not have a time limitation on their investigation, and the judicial review provision is not as clear. I'll say it's just not there, but there's some confusion about, or not confusion, but there's some potential discussion about what would happen after that order was issued. And I'll just say it's unclear in the bill. There are some current law
In the
provisions.
Senate version.
In the Senate version. There's some current law provisions that could kick in to allow review, but it's not as spelled out as it is in the House bill. So I'll stand on that statement and not get into the weeds too much. And then the only orders that would be essentially sent out would be orders of violation. And those would still go to the Attorney General, but the Attorney General would be required to impose the civil penalties. They would not have to go to court to impose those. And to facilitate a little bit of due process, the judicial review would come after the Attorney General issued a final order saying what the civil penalty would be. So they would have the same judicial review action, but a little further down the line. And again, only in the case that an employer is found to have violated it and gotten that far. So that's the main difference in subsection C of the two. The other main difference between the two bills is that the new version of the House bill as amended by the Senate has the unemployment provisions that were in Senate Bill 1. Very briefly stated, because I'm not an unemployment person, but I've become knowledgeable about this section over the last couple weeks. If you are otherwise eligible for benefits under our employment security law, there is a special provision made that you do not become ineligible for benefits and you are not disqualified from benefits under a couple of statutes if you were discharged or suspended for misconduct and your employer's conduct in discharging or suspending you was a violation of this section, or you're declining to accept work that requires compliance with one of these requirements if you've requested an exemption and you were denied. And so that would allow you to claim that that is not suitable work for the purposes of the employment security law. Those are the only two exemptions provided, though. Otherwise, you're subject to every other rule of the employment security law and all other limitations. The other piece of it is a retroactivity for benefits. So the Secretary of Labor and other claimants themselves could look back to the period beginning on September 9th of 2021, which was the date that these orders were announced by the President's administration. If anyone would have been eligible for benefits and was denied on the basis of any of the things I just talked about, they could have their benefits given retroactively. So that's the two pieces of the unemployment piece. And then I think the last difference is that in the Senate bill, there is no sunset provision, and in the House bill, there is, of June 1 of 2023.
Anyone have questions of the reviser? Appears they have no questions. We've all done our homework. I would like to just step outside with my party here, and I have an offer I'm considering making to the Senate, contingent on a number of other concessions on behalf of the Senate, if they're willing to concede certain points. But so we're just going to step outside real quick. Is that all right? Yeah. And thank you for the courtesy of allowing us to step outside and discuss a proposed offer that we are considering. But before I do that, I would like to have Jason. He indicated he left out a couple of little portions. Go ahead, Jason, please.
Thank you, Mr. Chairman. Jason Thompson with the Revisor's Office again. I apologize. I left off the two Senate floor amendments that were added. I just overlooked them on my copy here. One was that no employer shall impose a COVID-19 vaccine requirement unless the requirement is expressly authorized by an act of the legislature. And the other one is that no employer shall discriminate against any employee on the basis of whether such employee has received a COVID-19 vaccine. And obviously, neither of those are in the House bill.
Got a question on the second one, on the discriminatory clause. Does that allow, in your opinion, and you're the reviser, so I always respect your opinion, would that allow for another cause of action? A separate cause of action?
Mr. Chairman, I'm not sure that it allows for a cause of action necessarily. I'll start by saying it would be a violation of this section if an employer did any of that, right? So you'd have the action allowed here, but that's a complaint process.
Right.
We do have a statutory prohibition enacted in 2012 or so that says no statute shall create a private right of action unless it's specified.
Right.
So I'd lean on that to say if you don't specify you have an action here, then you don't have an action. But I could also see your point that if it says discrimination, we might be getting into a different kind of suit that's not a state lawsuit, right?
Right.
And so
It would be a federal.
So to your point, it's not a direct suit, but there could be a possibility that it could be a lawsuit.
Okay. Yeah. As I used to tell litigants all the time, you don't need a good case to file suit. You just need the filing fee. So hopefully doesn't mean you'll prevail. Anyways, I've conferred with my colleagues, and we do have a proposal. And you can take time to review it. I know this is rushed, but, you know, you're on the committee. I've been on the committee. You know, my vice chair has been on the committee. We know more about this probably than most people. And as the chair lady was indicating, she was a taskmaster on the committee. We heard so much testimony, but you did a great job. But this is what I'm proposing. I think the House version is a better version. I think Jason would indicate portions of it is probably better drafted, and it's clear. So we would consider we'll make the offer that if the Senate, in its wisdom, would accept the House version, that we would take your second part, which is your unemployment, because we understand that that may not really have an impact too much on the employment system. And our Chairman of Commerce has told us that, so that's helpful. We'd also like to have, and we understand it may be an existing statute now, and I'll ask Jason that, the clawback portion of it, whereas if somebody's double dipping, that the Department of Labor would be able to take that money back if they were getting money both from unemployment and if they've been reinstated on their job. We would like a severability clause, and I would call this, and you remember we worked on this years ago and when we did the judicial appropriations. I'm a big severability clause guy, and you were willing to accept it at that time, that if, and Jason, you'll have to probably draft this if they agree to it, that if the unemployment clause, because you have to work with the U.S. Department of Labor, for some reason would be found unconstitutional, that the first part, which would be our bill, could stand alone. Okay? However, if our part of the bill was found unconstitutional, the entire bill would go away, because you don't need the unemployment section if the first part of it is found unconstitutional. So it's kind of, if one part is found, if the unemployment is found unconstitutional, the bill can still survive. If the first part of the bill is found unconstitutional, the entire bill would go away. And Jason, I don't think it's that difficult to draft something to that matter, but you tell me. I'm sure you're the drafter. And the other part is the unemployment fund, the trust fund. Why should the fines go to the state of Kansas? We would, you know, we would like for that to go to the unemployment fund. It just makes sense. And I know I've given you several things, and you've not talked among yourselves or anything, but I think we're being overly reasonable here. You know, I've worked for you or with you for 10 years here, and I've always found you to be a very reasonable person. And in this type of context, you know, I have to present or uphold the House version. And I know you have to do the Senate, but these are, I think, reasonable compromises, but it's entirely up to the Senate. If not, we'll continue to talk.
As long as you're not being overly reasonable. So just for my own clarity, I'm going to repeat what I think I heard so we know, I understand what you're offering. You're wanting the House's base bill.
Yes.
Net effect, meaning no floor amendment from the Senate. You will accept unemployment, our unemployment provisions with what I heard were 3 caveats.
All right.
One is you want this severability piece that allows if UI drops, exemption stands.
Mm-hmm.
If exemptions drops, the whole bill falls.
Correct.
You want the proceeds of any fines through the administrative process to go into the UI fund versus the general fund.
Exactly. If there's a fine imposed, it should go to the unemployment fund.
You had one other, and it was what you would call double dip
callback.
or whatever. So if
And
if an
Jason
individual,
tells me that's in the existing statute, I'm fine. I just don't want people to double dip.
what I think you're trying to get at is so somebody would not be able to both receive back pay through the administrative process and unemployment.
Correct.
Okay, so that's your offer
That is my offer.
at this point. Okay, then yeah, we'll do the walk at this point. We'll be back in.
We always like to see the Senate walk. Mr. Chairman, I'm glad to see you back.
Thank you, Mr. Chairman. Yeah. Well, being deeply familiar with the bill and quick thinkers.
As in the Senate.
I do have a question.
Okay.
There was a piece that was slightly different in your administrative process. So this includes the attorneys general's having a court action at the end. That's in the proposal? That's not a difference since it's your underlying bill, that includes that piece from the attorney general?
It does. We just included in an earlier phase of those proceedings where your bill has the Judicial Review Act a little later after the Attorney General makes the decision or fines or whatever he should do, whatever he did.
So-
I don't think that that's a big difference.
So I've got a little counter offer for you, and then I think we'll have to have the discussion around, it sounds to me like we may have to have an agree to disagree with signatures. It would be good to get at least a general understanding in place. So my counter to you is, I don't believe there should be a sunset on people's religious liberties. And so we would ask that sunset be removed, and that we'd like to go 60 days on your 25 days. And if you're accepting of that, we have a deal subject to getting an agree to disagree in place. Because my ranking has expressed that they are not interested in signing regardless.
Okay? Would you mind if we step out?
You hear this?
Mr. Chairman, I thank you for the courtesy of letting us step outside. While I was outside, Jason came to me about the severability clause, and I would like for us all to have a clear understanding of how it would be approached. So I'm going to ask Jason to give us how they go. And it's very similar to some other bills that I've done in the past. But Jason, if you would, please.
Sure. Thank you again, Mr. Chairman. Again, Jason Thompson with the Revisor's Office. So we did some quick looking at some other models like this in past, and I've got some other attorneys that are suggesting we approach it like one section for the exemptions, one section for the unemployment, and then a third section that's essentially a repealer and a severability kind of together. It would have a provision that says, in the event that any portion or all of the exemption section is held to be unconstitutional, and the Attorney General certifies that that's a final order, then the Secretary of State would take that certification, publish it in the Kansas Register, and then we would trigger a provision that says Section 2 is repealed. The unemployment provision is repealed. So it sort of automatically does what you were saying. One struck down, the other one falls, and is taken off the books. Then there's another piece you could add. It's in your discretion. So we're just suggesting, if you wanted to make clear that your intent is that the severability doesn't go both ways, you could say in a third piece that if Section 2 is declared unconstitutional, that the provisions of the act are severable, which would save Section 1. And as you all know from hearing me say this before, severability is just advice we give to the court. They can choose to ignore it. The repealer is a little more direct. That's a legislative enactment that says we would repeal it through this process. Still some court option there potentially, but much clearer and would get to your purpose, I think. But because it requires such a substantial change, I'm glad that I could ask you if that's going to be acceptable, because I wouldn't feel comfortable bringing that to either of you and having you sign it without talking it through.
And I thank you for bringing that to our attention, and I think you've artfully drafted or made the proposal, and I'll leave it up to the chairman to chime in.
As long as it functions legally as described, which I think it would, I think we would be accepting of that.
Thank you. And Jason is correct. Courts sometimes ignore the severability clauses, and with this, there's another mechanism which will kind of double down and ensure that they'll have more things to consider. So if that's agreeable to you, that will be agreeable to the House version.
So is it your understanding we will need to run and agree to disagree?
It is from my side.
Okay. So I think we have a functional agreement, and then as we come back in at 8, we'll run for our...
And we will agree to taking out the sunset. And after some discussion, some of my members think 60 days is too long, but it's better than 100 days. So,
It's 40 days less.
yeah, 40 days less. So we are willing to accept the 60 days for the investigation, because it's unknown at this time how many cases they're going to get.
Right.
And we don't want those to fall behind. So I think 60 days is reasonable. Some cases take longer than others. Some of them will be a slam dunk, and some of them will take more inquiry by their investigators. So we can accept that with the understanding that, at least from my side and maybe from your side, that we'll have to do a motion to agree to disagree.
Very good. Sounds like a plan.
That's better than I thought it would go.